The prosecutors now have a major witness against Sarah Boone, and there could be more to come, but also the defense is attempting to suppress a major piece of evidence. But we need to begin with talking about her old lawyer, because they appeared in court. You can find the hearings online if that interests you. Essentially, they talked about being gaslit by her. They talked about how she had her own interpretations of the law, all the work they did. Essentially, they wanted to get $15,000. They feel they were owed the $15,000 for the case each, while JCAS, I think it is, was arguing that it should be split between them. The judge ended up siding with the lawyers. They're getting their $15,000. Plus, I think one got $1,800 more for other spending they did. But let's talk about the prosecution's notice of supplemental discovery. Comes now the state of Florida, by and through the undersigned assistant state attorney, hereby makes the following information available to the defense and states following. Abraham Moreno gave a statement to law enforcement in this case, which has been provided in discovery pages 237 to 247. The undersigned assistant state attorney spoke with Mr. Moreno in advance of trial on September 23, 2024. So this is just from the same day it was filed. Mr. Moreno indicated to this ASA that the defendant was stating that what happened was an accident on the day of the murder. Mr. Moreno said that the defendant stated that she was teaching him a lesson and things got out of hand and that she fell asleep. Mr. Moreno recalls the defendant making the statement prior to law enforcement arriving on scene. This is extremely important because her saying it is an accident, if it's an accident, it can't be battered spouse. So this is a major, major thing. And the reason this witness is probably coming forward now is it wasn't up for debate before whether it was an accident because Sarah Boone said it was an accident. Speaking of what Sarah Boone had to say, this is the motion to suppress defendant statements at OCSO. Comes now the defendant, by and through the undersigned attorney pursuant to Rule 3.190B, Florida Rules of Criminal Procedure. We're going to skip through here. Then respectfully moves the court to suppress all statements made by the defendant during her interrogation at the Orange County Sheriff's Office, and in support thereof states as following. So they want to get rid of her entire interrogation footage, that really damning piece of evidence. The defendant, Sarah Boone, is charged by way of information with a single count of second-degree murder. On or about February 24, 2020, the defendant called 911 in response to finding her boyfriend, George Torres, deceased. Deputy Kayla Rodriguez of the Orange County Sheriff's Office, OCSO, arrived on scene with her body cam activated. Deputy Rodriguez spoke to the defendant and realized the death had occurred. Deputy Rodriguez advised her supervisors and secured the scene. Sometime later, homicide investigator Chelsea Connolly, aka Chelsea Copesel, and Scott Lowen arrived. These two investigators would ultimately be responsible for this homicide investigation, were involved in the interrogation of the defendant at the OCSO the next day. The defendant was ordered to remain on scene while the OCSO conducted their investigation. The defendant stayed outside of her apartment for approximately 14 hours during this time. At some point, the defendant was asked to get into a vehicle with Detective Copesel and Detective Lowen. Once inside, Detective Copesel recorded an interrogation with the defendant after partially reading her Miranda rights, omitting the final question. So they're saying that the interrogation in the vehicle omitted the final question. The defendant was advised this recording interrogation was routine protocol and official procedure for any death investigation. During the investigation, Detective Copesel asked to see the defendant's phone. The defendant complied and gave her phone to the detective. The defendant was asked to unlock her phone, and she complied with the demands of the lead investigator. After Detective Copesel had the defendant's phone for a period of time, she came back and told the defendant that she was taking the phone. Detective Copesel asked the defendant to sign a form releasing it to the OCSO for further investigation. The defendant acquiesced to authority and signed the form. The defendant was told that one of the detectives would return her phone to the defendant at her apartment in Winter Park the following afternoon. Later that evening, the defendant moved to her ex-husband's home, Brian Boone, for the night. Using her ex-husband's phone, the defendant called the lead detective, Chelsea Copesel, to express her concern that Detective Copesel was not being truthful about law enforcement motives as it relates to the defendant. The defendant told the detective she believed that were trying to trick her. Believe that I think they's supposed to be there. The detective assured the defendant that they were not trying to trick or implicate her, but that the following day the defendant needed to drive to the Orange County Sheriff's Office to retrieve her phone. The detective explained the reason for the change in plans was because she was pregnant and not feeling well. The next day, February 25th, 2020, the defendant arrived at the OCSO to retrieve her phone and had questions about this tragic event. So, let me repeat that. The next day, February 25th, 2020, the defendant arrived at OCSO to retrieve her phone and had questions about this tragic event. Now, to me, and maybe this is a me thing and has no legal standing at all or doesn't matter, that sounds like she talked herself into an interrogation a little bit. If she has questions, it's probably going to go back and forth. Well, under the impression that she was retrieving her phone, Detective Lowen led the defendant upstairs into an interrogation room. A custodial interrogation ensued. Immediately after the interrogation, the defendant was arrested and charged with the offense above. So see, that's the thing. She had questions, but was she under the impression they were going to also talk about questions? That's the thing, right, between these two. I wonder. I don't know. They couldn't exactly leave it out if there's like body cam or security cam where she says she has questions. But if she knew what she was walking into involving questions, you would, I think, expect as an adult that it's going to go both ways. So let's continue. The approximate 2-hour interrogation was recorded. The initial dialogue between Detective Copesel and defendant Sarah Boone. And I'm going to be very honest right now. They do not have the whole interrogation typed out like this, so you don't have to worry. Detective, I'm going to have you sit in the green chair. Detective, appreciate you coming in. Sarah Boone, yes, ma'am, and I want to ask about these whenever you have a moment, referring to her written notes with questions. So right there, again, she wanted to talk. Again, I don't know if that legally matters, but to me it does. Personally, in my opinion, she knew what she was getting into. Detective, sure. So obviously he received his autopsy. Detective, so I'm going to read you your rights again because we have to talk about that. And they underscore that part. We have to talk about that. Detective says, and we're not done talking about the incident. Detective, we just have to do it. Sarah Boone, just like we did yesterday. Normal protocol. Detective, just like we did yesterday. Detective, remember I read you the rights. Detective, yeah, the exact same thing, but since I'm asking you follow-up questions, I need to read them to you, okay? And the detective says, so you have the right to remain silent. Anything you say may be used against you in court. You have the right to talk to a lawyer before and during questioning without charge. If you cannot afford a lawyer, one can be provided for you before questioning without charge. Has anyone threatened you or promised you anything to get you to talk? No. And do you understand what I just read to you? Yes, detective. Perfect. Okay, so this morning we went to the autopsy and we were informed some injuries he had by the doctor, defendant Ware. So he's got scratch marks on his back. So that is their part from the interrogation they're using. The interrogation continued for approximately 2 hours. At the end, while still in the interrogation room, the defendant was placed in handcuffs and arrested. The detective read the defendant her Miranda rights directly from printed card of the OCSO. The defendant omitted the final question from the standardized Miranda card for the Orange County Sheriff's Office. The detective omitted the same Miranda rights question that she omitted the day before, so they're saying the same question was omitted both times. The final Miranda rights question is, having these rights in mind, do you wish to talk to us now? The defense has yet to receive a true and accurate copy of the Miranda rights card from the Orange County office. Upon information and belief, it will look something like this. So, this is not the Miranda rights card. This is what they think it would look like. And as you can see below number 5, it has waiver, and then it says, do you understand? Based on all the circumstances surrounding the interrogation, the defendant's statement was coerced, not freely and voluntarily given. The defendant did not freely and knowingly waive her rights under Miranda. As such, the entire 2-hour interrogation should be suppressed. Therefore, the defendant requests, pursuant to Rule 3, moves to suppress the oral statements made by the defendant during interrogation. So, I feel like we went through this, didn't we, in the court appearance? I feel like we did. Maybe I'm wrong. That the judge was asking, like, well, what is it? Kind of asking, what does it matter? Like, if that final part, while it might not be protocol, doesn't violate Miranda rights. Like, that's what I was getting. So to me, this is a rehash of what was said in court that didn't work, and the judge didn't seem that impressed with, so I don't think it's going to happen. I mean, I guess they're trying it, right? But I don't see this. I don't see this one working at all. Yeah, I didn't read all the way through it. I kind of skimmed it. I was expecting them to have something else, right? I guess they do. They said that they're claiming that the final line was skipped both times, right? But so what? It's a break in police procedure, but I don't think it's a break in rights, if that makes sense. So yeah, there's other stuff filed, of course. I haven't covered all of it because all of it I don't think is really like needed in a video like this to have an idea of what the case is going through. And of course, like I didn't individually go through all the different the lawyers getting paid. They're getting paid. With that being said, I do have a game coming out, I believe tomorrow, that I'm probably going to put a lot of time into for at least a few days. So any coverage of Sarah Boone or other stuff might be delayed a little bit. But I want to make sure I get this video out while I can, because I think it's very interesting. Mostly that we're now getting new witnesses to confirm that she called it an accident. Because remember, now if he's going after this here, he's going after this interview. Even if this 2-hour interview is pulled, they have witnesses of her saying it's an accident. She said it's an accident so many times. Do they need the interrogation to prove that she said it was an accident? The interrogation helps with other things, but the fact that, battered spouse doesn't apply, I think they can make that argument without the interrogation.